a little makeshift stage here if she's ready. Senator Ann Cools is Canada's first black senator and was the longest-serving senator upon her retirement on August 12, 2018. She led a joint Senate House of Commons committee with MP and Cafe Advisory Fellow Roger Gallaway, who I think is here with us, sitting right there beside Ann. The committee was looking at how to include aimed at reforming child custody laws, and that committee ended up recommending shared parenting in its landmark report for the sake of the children. As a social worker, Cools was a pioneer in the protection of women from domestic violence, running one of the first domestic violence shelters in Canada. During her career, she became equally enthusiastic and courageous as a voice for boys and men, championing fathers' rights, shelters for abused men, and proper procedures around sexual assault allegations. During her 34 years in the Senate, Senator Cools traveled across the country and met and spoke with Canadians in all regions. Over time, she found that public opinion shifted and became more open and favorable to the needs of addressing men's issues. In this talk, she will discuss changes that she saw in public opinion regarding men's issues, policy formation, and recommendations for action that we can take to promote fairness and equality for all in the law. I've been hoping to have Senator Cools as a cafe speaker for a long time here in Toronto. I'm so glad we can finally fulfill that goal. Senator Cools, will you please join me?
Could I sit? Would that be okay? Because I have some documents. Oh, I can manage. I would just like to say that I am always. Is there any way I can bring this down a bit? Does this work? Perhaps, yes. Perhaps I should like to begin by saying that it's always a pleasure for me, at any rate, to speak at a meeting where we're looking at the condition of children's lives, really, but through the eyes of their parents. And a lot of work has gone into this issue in the last many years. And I would like to take the opportunity here to thank my dear friend and colleague, who is Roger Gallaway. And Gallaway, I always call him Gallaway. I'm British. I was born in the British environment, and we always, as girls, we always called each other by last names. So Gallaway was very important in this whole process that we had, which I would describe as a discovery of the real public opinion on issues concerning children. And with that in mind, many of us pushed for a committee to travel the country. You call these parliamentary committees, and they can be of the House of Commons, they can be committees of the Senate, or they can be joint committees. And in our case, it was a very special situation because we got a joint committee, and we need it or not. Our friend Roger Gallaway here was the chairman from the House of Commons, and we know why I never got to be the chair of the Senate side, but that didn't matter at all because our committee succeeded in carrying public opinion in a very profound and wonderful way, the likes of which I have never really seen or encountered on any other parliamentary committee. So I thought what I would do today perhaps is to look at the issues of law, what I would consider the issues of law, and to try to get some insight into the position that so many fathers have been put into, this very unfortunate position where they always seem to be begging to be able to see their children. I have heard so many episodes and stories. One of the bad ones that I once heard was of a particular father who was trying to take his children. The children were born in England, and he was from England. And she had said could get the children to take them to England to see his mother or father, whatever it was. And so she said, oh yes, you can have them, you can pick them up at 6 o'clock, 5 o'clock, whatever time. And this man saved his pennies for weeks and weeks. And when he went to the door to get the children, she said, no, I've changed my mind. That kind of pure humiliation that so many men have gone through. So what I would like to do here today is to take a look at a term that is called the best interest of the child. I'm sure it has become very overworked and very well used in recent years. But I would like to share with you that that term has a very important origin, and I would like to share some of that with you if you don't mind. And if some of you find it too dry, we can shift gears very, very easily. So I would like to begin by saying that the term the best interests of the child has its origin in a chancery court, the Court of Chancery in the United Kingdom, in an 1893 case. And this, is there any way we can push it back a bit more? Over this way, thanks. And I would like to begin on this particular. Now, dear friends, my subject here this evening is best interests of the child. By the Constitution of Canada, children's affairs, particularly their good health, well-being, and education, are vested in our provinces and in our provincial jurisdiction, and not in our federal jurisdiction. The provincial statute in 1914, I'm going back, I'm digging back. In the 1914 Ontario Children's Protection Act, and I want you to see how this is going to change over time. Section 22, bracket 3 said, quote, where it affairs to the judge of the public interest and the interest of the child will be best served thereby, an order may be made for the return of the child to its parents or friends, or the judge may place such child under the guardianship of the Children's Aid Society or of an industrial school. So I'm just giving you some insights on how old your problem is. It's a very ancient problem that keeps popping up its head. I note here the likeness of the phrase, the interest of the child, to the phrase, the best interest of the child, which is found in many provincial child protection and child welfare statutes. In our federal jurisdiction, there are only 2 statutes that are directed towards children. These are the Divorce Act and the Youth Criminal Justice Act, formerly called the Young Offenders Act, formerly called the Juvenile Delinquents Act. All these statutes were born in the late 19th century genesis in and birth of the social notion that we call child welfare. It's quite a recent term if you think about it. The 1929 Juvenile Delinquents Act's legal conceptual framework was twofold, in that it included 2 concepts, the welfare of the child and the parents' patriae. I'm sure many of you here are lawyers, and you know the term parents' patriae. But the term parents' patriae means that the king, as the parent of all the children, has these powers in respect of the rights of children and things and events of children. These conceptual frameworks treated juvenile delinquency not as an offense, this is very important, but as a condition in the child. Remember, we were talking about the beginning, the birth of social welfare thinking. Not as an offense, but as a condition in the child. Which condition was the child's need for parental care, guidance, and supervision? You see, this is changing from the Charles Dickens, the Oliver Twist, and so on and so forth. The world is changing in a dramatic way this way. This Act, Section 3.2 said, quote, where a child is adjudged to have committed a delinquency, he shall be dealt with not as an offender, but as one in a condition of delinquency, and therefore requiring help, guidance, and proper supervision. From this conceptual framework was born the juvenile courts and later the family courts. My friends, in Canada, until 1968, divorce was difficult, I hear it still is a bit way, costly and rare. Divorces in Canada proceeded by the British 1857 Divorce and Matrimonial Causes Act in all the provinces, except in Quebec and Newfoundland. where divorce bills were actuated and moved by senators as individual private bills, a very costly process it used to be, in both houses of Parliament of Canada. Originating as a private bill petition in the Senate, these individual divorce bills were debated and voted there. Then, without amendment, they were voted and adopted in the House of Commons. Then the bill was presented to His Excellency the Right Honourable Governor General of Canada for the Royal Assent. Do you know what the Royal Assent is? The Royal Assent is the agreement of Her Majesty's representative, who is the Governor General of Canada. And that agreement, this is the Royal Assent that the Governor General gives to the bill on behalf of Her Majesty, the Queen of Canada. So Canada enacted its first, so those bills were getting Royal Assent. When I first came to the Senate, I have to tell you, in 1984, there were still several of those bills floating around between the two houses. So I'm very well aware of this. So Canada enacted its first real federal divorce act in 1968. That is very recent in time. So here we have, in 1984, the best interests of the child and its conceptual framework were proposed for the Divorce Act by Liberal Minister of Justice and Attorney General Mark McGuigan, who had offered his divorce reforms in his paper titled Divorce Law in Canada, Proposals for Change. This paper was widely circulated and debated and agreed to by Canadian lawyers and scholars. Minister Mark McGuigan was a legal scholar with a well-trained, disciplined, and active intellect. He had also been a professor of law at University of Toronto here. In 1984, he was appointed as a judge of the Federal Court of Canada. His 1984 Bill C-10 on the divorce died on the order paper when Parliament resolved for the September 4, 1984 federal general election to roll your minds back. In time, that's when Cimarroni is elected in 1984. The new Conservative government's Justice Minister John Crosbie, he was very industrious on the bill too, reworded Bill C-10 and introduced it as his own Bill C-47. Minister of Justice Crosbie's bill retained Minister McGuigan's best interest of the child legal framework that was founded in the two concepts, the parent's patriarch and the welfare of the child doctrine. In 1986, Bill C-47 was enacted and is still a large part, a lot of that bill, still a large part of the current bill. Dear friends, the origin and pedigree of the enduring phrase, the best interests of the child, are neither well known nor understood. For many reasons, including the now gone 1980s and 1990s, I hope I don't invite anybody's distress, period of gender feminism that stifled equality feminism. Gender feminism held that women are morally superior to men, that men are morally inferior to women, and possibly morally defective. This gender feminism also held that moral and humane behavior are gender traits, that goodness and virtue are female, and that aggression, violence, and evil are male. And despite compelling evidence of growing gender parity in both fronts, it also disfigured the application of the criminal law in physical and sexual assault cases and in divorce law cases in child custody and access and in child and spousal support. There's a real division happening there, and a very cruel one, fathers and men. In divorce, this was taken to mean that mothers should have primary and greater parenting rights than fathers. In addition, many feminist lawyers expanded and held that domestic violence cases should be decided by something called women's credibility. Women's credibility held that because women are truth tellers, their physical and sexual assault accusations against their male partners should be treated as findings of guilt automatically. Those years saw a plethora of false accusations in divorce and child custody proceedings. This time was a heart of darkness. I remember it very vividly, and I can tell you it was soul destroying for fathers of children and for the parents, not only fathers of children, but the parents of those fathers. And in addition, terrible pain for the fathers' new spouses and partners. It just straddled the things that we should have been doing. Because many of these fathers and spouses and new partners had to live a new life. And I have to tell you, I used to have more, my husband stopped going to the grocery store with me on Saturdays because I could not walk 10 feet without, usually it was one of the mothers or the mother and father come to me and say, Senator Coles, could you make a few minutes to talk to me about my son? And the story would start. My son hasn't seen his children for X months and he has custody, on, very painful. And my husband was very sympathetic to me, but he stopped going to the store with me because he just couldn't get through the grocery store in an hour or two. Anyways, I'm continuing. So this was a heart of darkness, and that's the word I use for it. But I just know it's soul destroying for fathers and children, for their fathers, for parents, and so on. The 1994 case, DB, it doesn't matter, Jesse, DB versus Children's Aid Society of Durham Region. Justice Williams Summers spoke about a witness. This woman's name was Miss Chisholm, Barbara Chisholm, and this is about this case now. Ms. Chisholm indicated that the experience has been for some time that sexual assault allegations made by a mother against a father in custody disputes are very prevalent nowadays, and indeed have become what she called the weapon of choice. And I trust me, believe you me, it was the weapon of choice. And I saw many men broken and being destroyed by an accusation like that. Dear friends, this female privilege found help in Liberal Justice Minister's 1997 Bill 41, an amended Minister Property and Divorce Act, which added the best interest of the child as a conceptual framework, and which had embraced gender equality in parenting and family life. Bill C-41, something we'll remember, set out to repeal the 1986 Financial Equality Section 15A, which had enacted shared financial obligations for both mothers and fathers in the support of their children. Section 15 said, this is the group that you belong. An order later, this section provides for the support of the child in marriage should, quote, A, recognize that the spouses have a joint financial obligation to maintain the child, and B, apportion that obligation between the spouses according to their relative abilities to contribute to the performance of the obligations. Dear friends, shared obligations were key to the child-centered gender equal 1986 Divorce Act reforms. These reforms have followed 1970s provincial family law reforms that enacted joint and shared property ownership of the matrimonial home. I hope you all remember when that was created. That when divorce, if the couple breaks up, they have to divide the matrimonial home equally. Our attorneys general of Canada's province had decreed the sharing of the marriage property. The new federal divorce law had followed and enacted shared financial and affection and care for children of marriage. These 1986 Divorce Act reforms also spoke to the important issue that was wives' financial dependence on husbands. We all remember the Thibodeau case. Section 15.2.16, objectives of spousal support orders. It decreed that support payments must, and so far as practicable, promote the economic self-sufficiency of each spouse within a reasonable period of time. Another 1896 Divorce Act Quality Reform was the friendly parent rules. Section 1610 says, making an order under this section, the court shall give effect to the principle that a child in marriage should have as much contact with each spouse as is consistent with the best interests of the child. And for that purpose, shall take into consideration the willingness of a person for whom custody is sought to facilitate such contact. In 2003, Liberal Justice Gauchan's Bill C-22, and this didn't go very far, anyway, set out to repeal the friendly parent rule. Thankfully, Bill C-22 never became law. We worked hard for that. Dear friends, forged in the Parents' Patriot Doctrine by our sovereign Queen, the supreme guardian of children, and our superior court judges owe the children of divorce the most high duty of decisions in the children's best interest. Minister John Crosby's bill that offered a child-centered approach to the Divorce Act had held great promise for balance, fairness, and equilibrium in divorce. Sadly, later by other amendments to the Divorce Act, Bill C-41, set out to defeat those reforms. Bill C-41 repealed the Divorce Act gender equal child support sections and replaced them with something that we call the then new federal child support guidelines. And some of you would remember when they were put in force. These enacted as regulations. You know what a regulation is in law? Okay, fine. Okay, you know it. As regulations to the Divorce Act decreed that child support payment amounts would be calculated solely on the income, of the non-custodial parent, mostly and mainly fathers, and paid to the custodial parents, mostly mothers. These calculated amounts did not factor in the custodial parent's income. Justice lawyers tried to convince senators that the custodial parent's financial contribution was assumed here to be paid right. Feigning the gender equality of the repealed child support section, federal child support guidelines were enacted as the Divorce Act sections 26(1)(2) that book. The guidelines should be based on the principle that spouses have a joint financial obligation to maintain the children of the marriage in accordance with their relative abilities to contribute to the performance of their obligations. Sounds like the repealed section, but it's not. Dear friends, regulations are delegated, or what we call delegated or subordinated legislation, decided by the minister in question. In this case, it's the Minister of Justice. The Child Support Guidelines launched the legal preeminence of the financial over the affectionate duties of parents to children. These regulated and dictated quantums undermine judicial independence and the judge's duties to children in child support decisions. The C-41's other Divorce Act change then decreed a court's duty to stay the divorce if the parents had not made reasonable child support arrangements for the children, so amended. The Divorce Act, Section 11, bracket 1, bracket B says, in a divorce proceeding, it is the duty of the court, quote, listen, to satisfy itself that reasonable arrangements have been made for the support of any children of marriage, having regard to the applicable guidelines, and if such arrangements have not been made, to stay the granting of the divorce until such arrangements are made. Now, that's a very, very important neglected section. No reasonable child support arrangement, no grant of divorce. I agree with that. I'm sure many of you would too as well. This section decrees no equivalent court duty to stay the divorce if the parents have not made a reasonable arrangement for parenting the children. The court's power of the financial money stream seems more weighted than the court's power in the affectionate stream. The Department of Justice lawyers told senators that these changes were needed for uniformity in child support payments. The Department of Justice seemed to be promoting a uniform child, from what I can see. The elevation of the parental financial duties over the parental affectionate duties is a strange angle with no place in the best interest concept, best interest of the child, which was the conceptual framework of the then new Divorce Act. All this was enhanced by the Income Tax Act changes that ended the regime that the income tax on child support was to be paid by the lower income custodial parent recipient, mostly women. Now the higher income non-custodial parent, mostly men, would pay. Many hail the divorced family's loss as a windfall to the Treasury. Dear friends, today I laud the late and great Martin McGuigan, who enshrined the best interests of the Child Divorce Act's legal and judicial framework, because all these reforms really began in Martin McGuigan. For him, the first of the child's best interests was ever always the child's interest in his relationship with his own two parents, both mother and father. He set out to effect and actuate shared parenting by enlisting the legal judicial conceptual framework, the best interests of the child, as a standard for a judge's decisions. By this, the Divorce Act vested Canada's children as persons separate from their parents with rights to which they're entitled by law and by nature's sacred decree that human life, children, people, is the result of two parents. The legal phrase best interest of the child is used 5 times in the Divorce Act, twice in Section 16 for court orders in custody and access, and 3 times in Section 17 that varies your sentence or suspends orders. Dear friends, now to the legal phrases pedigree in the common law and in the ancient British King's Law. you know the difference between, do you know the difference, most of you must know the difference between the common law and other law.
Civil.
And civil law. But no, but see, the common law and then the other law in the bigger courts. The common law is grew out of ordinary people who are not very well educated, so a lot of the language was formed. But anyway, this is really matter. We're moving into the supreme, as the supreme guardian of the parents patriarch. So the king is the supreme guardian of children. Long ago, the king delegated this power to the Lord Chancellor, the highest judge of the land after the king himself. The Lord Chancellor is the keeper of the great seals and the keeper of the king's conscience. In his ancient courts of chancery and equity, the Lord Chancellor exercised this unique jurisdiction to protect children and the vulnerable in equity. So we're looking away from the common law, we're looking to the law of equity. And later his codes acquired the powers of the king's courts of wards and liveries, very important, which originated when the children of the knight who were fighting for the king and were killed, so being killed in the king's service, those children became the wards of the king. Remember the old story of Robin Hood, he made Marion, remember she made Marion was the ward of King Richard. So became wards of the king who protected them and their property and delivered their wealth and property to the children at their maturity. Later still, by the 1873 union of the common law, chancery, and equity courts, all high and superior court judges were vested with these high equity powers as guardians of the children. Dear friends, the parents' patriarch, quote, is the ancient but extant power of the queen as the country's supreme parent and children's guardian. Black's Law Dictionary, 6th edition, defines a parent's patriarch at page 1140. You don't have to see that page down here. Parent's patriarch originates from the English common law, where the king had a royal prerogative to act as guardians of persons with legal disabilities such as infants. Jolliffe's Dictionary of Law also says, at page 1294, the sovereign as parent's patriarch has a kind of guardianship over various classes of persons who from their legal disabilities stand in need of protection, such as infants, idiots, and lunatics. Jolliffe's Volume 1 explains the maxims of equity. Quote, equity acts in person, means person. Equity acts on the conscience. Equity will not suffer a wrong to be without a remedy. Equity follows the law. Equity looks to the intent rather than the form. Equity looks on that as done which ought to be done. Equity imbues an intent to fulfill an obligation. Equitable remedies are discretionary. Delay defeats equity. We've heard, and many people don't know, but now we know where it's coming from. He who comes to equity must come with clean hands. I'm sure that at least some of the lawyers here know the expression. Hence again, the courts of chancery and equity were from time immemorial, when literacy was rare but vital, and the clerics, the ecclesiastics, were literate, and therefore Lord Chancellors were chosen from among them because they could read and write. These literates and the literate clerks, we should call it word clerks, managed and recorded the legal process, hence the term the chancellor. The chancellor and the clerk, or the masters in chancery. So there are a few courts here in Ontario and in Toronto where they still have masters in doing cases in the courts. Now to Canada's Court of Chancery and its powers for children. In Upper Canada, in 1837, an act to establish a court of chancery in this province enacted and created this court with like powers for children as in Britain. This 1837 act, in section 2, said, quote, and be it further enacted by the authority aforesaid, that the said court shall have jurisdiction and possess the like power and authority as by the laws of England are possessed by the Court of Chancery in England in respect of the matters hereinafter enumerated. That is to say, in all matters related to, here comes the three, infants, idiots, and lunatics, and their states. Nova Scotia, by the way, and some other provinces in Canada also had chancery courts. Later, the Brits, by the 1873 Supreme Court of Judicature Act, merged their common law and equity courts, which union vested their superior and high courts and judges with the chancery court's royal equity powers to protect children and their property. Their 1873 Act, Section 25 said, in questions related to the custody and education of infants, the rules of equity, not the common law, the rules of equity law shall prevail. Equity is conscience. Like the British Ontario's 1881 Ontario Judicature Act merges chancery, common law, and equity courts. This vested the inherent chancery courts, equity powers for children in all of our high and superior courts and superior court judges. Like the British Act, the Ontario Judicature Act, Section 1709 and 1710 said, in questions related to the custody and education of infants, the rules of equity shall prevail. General law matters not hereinbefore particularly mentioned in which there is any conflict or variance between the rules of equity and the rules of the common law, with reference to the same matter, the rules of equity shall prevail. Equity's rules and conscience prevail. The law for children is ancient and true, though rooted in children who own the property. Dear friends, the legal phrase, the best interest of the child, was first settled in the celebrated defining judgment in the 1893 child protection case, Queen versus Gallaway, delivered in Britain's Queen's Bench Decision Court of Appeal. This court, by the 1873 merger, had acquired the parents' patriarch and chancery's equity powers. In Gingle, the 15-year-old child barely knew her birth mother. But this is a defining case on this issue. And it's Regina versus Queen versus Gingle. The 15-year-old child barely knew her poor birth mother, who was ever incapable and unable to take care for her. Much bumps around. The 15-year-old child, delicate health, was thriving in Miss Gingall's care. Remember, it is the Queen, Regina versus Gingle, and was trained to be a teacher's aide. She strongly opposed her mother's efforts to reclaim her. The child is 15 years old. I know that the judges met with her and spoke with this child, 15-year-old child, face to face. They actually did that, and this was a huge step forward when that happened. And I note that the child strongly opposed the mother's efforts to reclaim her. And I know that the judicial judges spoke with her and ordered the child to Gingle. The most learned, these are the judges, like when you hear these names, these are big names. When you start to hear names of British judges like Denman, Esher, those fellows, you're right at the top, right at the top. The most learned Lord Esher, the master of the roll, and the highest judge after the Lord Chancellor. Now remember, the Lord Chancellor was the highest judge after the King, because the Lord Chancellor had powers if necessary to cancel, that's why it's Chancellor, to cancel legal documents when necessary. The court led the court in this masterful judgment, and I really believe if you have a chance, and I have a copy of this, I haven't had it since 1893, but I've had it for many, many years. And I advise you, young people who are interested in assisting human beings in their trials and in these issues, to equip yourself by having a collection of these old documents. It's very easy to find them, and it's not hard at all. Anyway, I'm continuing. Now this is Lord Esher speaking. I was going to answer some more. This is Lord Esher speaking. And remember, he said, be master of the role that the highest judge after the chancellor. Led this masterful judgment. About the court's jurisdiction, Lord Esher wrote, quote, that there was another, remember before we were talking about the law, right, we're going into these other courts that the courts of cancer, that there was another and absolutely different and distinctive jurisdiction which has been exercised by the Court of Chancery from time immemorial. This was not a jurisdiction to determine rights as between a parent and a stranger, or as between a parent and a child. It was a paternal jurisdiction, a judicially administrative jurisdiction in virtue of which the Chancery Court was put to act on behalf of the Crown as being the guardian of all infants in the place of parent, and as if it were the parent of the child, thus superseding the natural guardianship of the parent. This is powerful law when these powers are put into these judges' hands. The present case arises after the Judicature Act, and the proceedings are in the Queen's Bench Division. That's another branch of the court. The effects of that act is, as I've often said, not to invent a new jurisdiction or to create new rights, but to alter the mode of procedure. So they're altering the mode of procedure. And there having been before two independent jurisdictions, one common law and the other equity, the Act in effect provides that if a person proceeds to the Queen's Bench division under the common law jurisdiction, and it turns out that the case raises questions to which the Chancery jurisdiction is applicable, the Queen's Bench division judges are not to send the suitor to Chancery Court, but they are to exercise the Chancery jurisdiction themselves. They're pretty hefty powers that they. So you can see that all during those years, between 1893 and I'd say when about 1930, you can see the system yielding to certain changes. So the Queen's Bench division are not to send the suitor to Chancery Court, but are to exercise a Chancery jurisdiction themselves. Lord Esdh went on. I figure if I don't mention that page, whatever, I get a bit of extra minutes, 2 minutes, not too many extra. In the case of Rhys Spence, Lord Cottenham, Lord Chancellor, said, I have no doubt about the jurisdiction. The cases in which this court interferes on behalf of infants are not confined to those in which there is property. This court interferes for the protection of innocents qua infants by virtue of the prerogative which belongs to the Crown as patriot, and the exercise of which is delegated a great seal, or leashes private still. How is that jurisdiction to be exercised? The court is placed in a position by reason of the prerogative of the Crown to act, listen, this is so good, to act as supreme parent of children, and must exercise that jurisdiction in the manner in which a wise, affectionate, and careful parent would act for the welfare of the child. Lord Esdh, and again. Then we have the case of in Reed McGrath, in which Mr. Justice Lindley and L.J. said, the dominant matter for the consideration of the court is the welfare of the child. It's so beautiful how they're coming back to this at every moment. But the welfare of a child is not to be measured by money only, nor by physical court. The word welfare must be taken in its widest sense. The moral and religious welfare of the child must be considered as well as its physical well-being, nor can the ties of affection be disregarded. The court has to consider, therefore, the whole of the circumstances of the case, the position of the parent, the position of the child, the age of the child, the religion of the child, so far as it can be said to have any religion, and the happiness of the child. Lord Justice King gets in between. Lord Harwick, professing not to go upon guardianship and disclaiming wardship, puts it upon this, that the court represents the king as parent patriarch. He added, the statement of the jurisdiction shows, arising as it does from the power of the Crown delegated to the Court of Chancery, it is essentially a parental jurisdiction, and that description of it involves that the main consideration to be acted upon in its exercise is the benefit or welfare of the child. In its parental jurisdiction, the court distinguished the child from his parents, or Justice King. Again, it's mine. So again and again in such cases where the child was not very tender years, the practice has been that the judge himself saw the child, not for the purpose of obtaining the consent of the child, but for the purpose. And it's one of the best modes of determining what was really for the welfare of the child. Dear friends, this 1893 case set the stage for the 20th century enriched legal judicial approach to children as human persons with their own needs, distinct and separate from their parents. And you can, if you read enough, you can see when the time, the era was changing, and so were the judicial practices, and so were the attitudes to children. The day was over when a child would be punished by put in a dark room by itself with a slice of bread for 2 days. Those days were over. And some schools used to do that with children. So anyway, Lord, as I was saying, for the world, in Queen versus Gabriel, Lord Justice Case states, for the world, for all humanity, the sensitive, well-established, and most famous words about the law on and for children. And that is found at page 252 of this doctrine of this particular. It says, as I have stated, the superintending power in respect of infants, which Lord Eldon said the Court of Chancery had always exercised by delegation from the Crown as parents patriarch, must be exercised as the court may think for the best interest of the child. And that is where that term comes from. And it's right here, page 252, because I know you're going to come pick it up. in a few minutes, I know you're there. But the best interest of the child phrase expresses the conscience, the humanity, and the judicial power of the sovereign and the state. Very important, and they just put it there for you. All you have to do is read it and absorb it, love it, and believe in it, and practice it. Dear friends, Minister McGuigan, and this is the reason that Minister McGuigan was so good on this phenomenon, because he himself was a legal scholar. And I believe that he used to teach right here at this university in Toronto. I believe that he taught here. I would have to look that up to confirm that. Anyway, Minister McGuigan Crosby planted this judicial phrase, the best interest of the child, as pedigree in the divorce law and lexicon to clarify and express the curial and judicial duties that are owed to the children of divorce. This phrase embodies and expresses the law that recognizes a child as an individual human person with rights, just like Janus Korzak's concept that children are complete beings from birth. I was invited to speak some years back in a series of lectures of Janus Korzak's name, and I was invited to speak at that meeting. And I just continue. Korzak was an Eastern Europe, Polish, that part of the world. And all of this is around coming up to World War I, after World War II, I'm forgetting now. But he would go around picking up children off the sidewalks. You know, children sick, terrible things, because children, there were so many around World War II, there were just so many children that were desperate. And he created homes for them. And somehow or the other, I don't know, but there was a Janus Korzak lecture series out of the University of British Columbia, and somebody wanted to do that, so I went to I did a speech, and I didn't tell how I went, and I spoke there. It is a common mistake to unite a child's interests. But just remember that children, Korzak, children are complete beings from birth. It is a common mistake to unite a child's interests with one or more parents. Gainall, in the cases set forth in the law, and lexicon expressing the individual complete humanity. Mindful of the harsh conditions in which children toil, this 1893 legal framework, the best interest of child, the best interest of the child, is one of the greatest contributions of the English High Court judges to the common law world. Page 12. I'm nearly done, folks. In the 1990s, when child welfare was then fully emerging, one writer noted, he'd written a book on children. One writer noted that in one night on a Toronto street, he counted 700 children. In those days, those children were described as ragamuffins, street urchins, street Arabs, begging and scrounging. And they would all go out at night and they would beg and scrounge and flutter, and then go home and give these findings or whatever they required to their parents. Pioneer Minister McGuigan and Crosby enshrined children's positive rights in the federal divorce law, distinct from the provincial child protection law. The child is its own person with unique needs that include adult parental care. Children cannot do without adults. Its legal disabilities and privileges that vest adults with duties to them. It is as this vulnerable separate being that a child needs the loving care of two parents. Dear friends, now to the defining 1925 American judgment in the New York Court of Appeal. The case is Findlay versus Findlay, and the judge is Justice Benjamin Cardozo. And guess what Cardozo is doing? He is applying Gingrich, Queen versus Gingrich in this case. So Honorable Justice Cardozo, here Cardozo is Benjamin, and a great human conscience and that sort of thing. He's Justice Benjamin Cardozo. The jurisdiction of a state regulated custody of infants found within its territory does not depend upon the domicile of the parents. It has its origin in the protection that is due to the incompetent or helpless. The clear-minded Justice Cardozo invoked the Lord Chancellor's common and equity law jurisdiction and cited Gingrich. And you have to know this would have been quite progressive for this American judge to start moving in this direction. Page 940. The Chancellor exercises his jurisdiction of the petition does not proceed with the theory that the petitioner or the father or mother has a cause of action against the other or against anyone. He acts as parents' patriarch to do what is best for the interests of the child. He is to put himself in the position of a wise, affectionate, and careful parent. He's pulling all of this out of Gingrich, and make provision for the child accordingly. He may act on the intervention or on the motion of kinsman. If so, the petition comes before him, but equally he may act on the instance of anyone else. Quote, he is not adjudicating a controversy between adversary parties to compose their private differences. Very important. He is not adjudicating a controversy between adversary parties to compose their private differences. He is not determining rights between a parent and a child or between one parent and another. He interferes for the protection of infants, qua infants, by virtue of the prerogative which belongs to the crown as parents practice. The plaintiff makes no pretense of invoking this paternal jurisdiction. He invokes the jurisdiction of a court to settle a dispute. Equity does not concern itself with such disputes in their relationship disputes. Its concern is for the child. This to me is so beautiful. I hope you use as much to you as it means to me, because I've read these a lot over the years. Equity's concern is the child. These two judgments, Gingle and Finlay, clarify the often overlooked fact that in child cases, the High Court judge's duty is not to adjudicate or settle disputes between parents. The judge's duty is to protect and decide the best interest of the child in circumstances. Dear friends, notice some potential misunderstanding of the best interests of the child. Well, this here. In Canada's Supreme Court's 1993 judgment, Young versus Young, Madam Justice Claire Dubé dissented, concurred in by Justices Laforêt and Gauthier. With access parent, she wrote, page 7, the role of the access parent is that of a very interested observer. Given love and support in the child in the background, if you were a father hearing this, you would not feel very good or very comforted. I didn't feel very good, very comforted as I first read it some years ago. With access, the role of the access parent is that of a very interested observer. And that he's often an interested observer. The custody, given love and support to the child in the background. Where's the background here, by the way? The need for continuity about the custodial parent, she says. The need for continuity generally requires that the custodial parent have the autonomy, to raise a child as he or she sees fit, without interference, without authority by the non-custodial parent. About the non-custodial parent, she said, quote, the non-custodial spouse with access privileges is a passive bystander who is excluded from the decision-making process in matters related to the child's welfare, growth, and development. This is a whole bunch of children's fathers, you know, it's, well, what it is. She describes men at page 49. I hope you're ready, gentlemen. Men as a group has not yet embraced responsibility for child care. Oh.
What year was that?
The judgment of Young versus Young, 1990. She describes men, page 49, men as a group have not yet embraced responsibility for child care. Dear friends, Queen's University law professor Nicholas Bell, in his 1995 article in the best interest of the child, was published in the Supreme Court Law Review, wrote on Young v. Young, Young versus Young, Madam Justice, she wrote. Justice Dubé wrote a lengthy dissenting judgment in which she emphasized that the best interests of the child are served by protecting the position of the custodial parent. He said on page 461, as in her 1992 spousal court judgment in Lowe versus Lowe, she offers an explicitly feminist analysis, discussing social science literature about gender, child care roles in marriage and after separation. Dear friends, Madam Justice was judge's sensibility. They just jolly sensibility. Equity's mind knows only the law of conscience, knows no social science literature, nor that the custodial parent is bystander. The best interests of the child's law and equity are not open to judges' private beliefs. Jurisdiction is clear that the judge's concern is the child, not the parent's conflict, not their gender, nor their gender roles. To the contrary, I think the balance is clear. The best interests of the child are more aptly served by a law which recognizes The right of the child to a meaningful post-divorce relationship with both parents. The right must be distributed between the custodial and the access parent so as to encourage such a relationship. Dear friends, the best interest of child legal framework is the Divorce Act to strengthen the court and the judge's duties to divorce his children. So sometimes family divorce law has been afflicted by divisive and unhelpful ideological debate. It is clear that when family relations are most tense, divorce proceedings are clearly poor forms for such debate. It is also clear that poorly drafted statutes will plunge all concerned into muddy waters. For this reason, the best interest of the child, this is Martin McGuigan, Minister McGuigan. For this reason, the best interest of the child is entrenched in the Divorce Act to give judges workable tools to do what they're constituted to do in judicial independence and in their royal duty to uphold children despite or in spite of spousal dispute. Innocent children must not pay for the sins of history or of their parents. Ideological claims place heavy burdens on judges who are neither family counsels nor magicians. The law of the best interest of the child decrees that the judges be just and fair. As the most complete and authentic legal tool affirming children's rights, the best interest of the child is not poetry, nor a well-intended expression of humanity. It is the law of a judicially administrative jurisdiction by the judges in their ken, the courts by their court orders. But its fate and future lay in the legislative ken, Parliament, and the provincial assemblies which enact laws. Thank you so much for your time.
We had some debates about what to keep in there.
Well, all of it was.
So, maybe a couple quick questions, John?
Yeah, Senator Nicole, so good to see you.
Thank you.
What I hear is tyranny. The judge gets to exercise some words, and there is no due process to challenge those words.
Oh, they are. You just haven't learned how to get to them. And it's a horrible thing when a man is sort of like out there hanging on by something that isn't very, very clear to him at all. And not all ordinary people, or most people, are not schooled in some of these things. They haven't spent, as I did the first time I put my hand on this document from 1893, going through every single word and page until I found it. A lot of these men, unfortunately, are quite distraught and feel violated and feel let down by quote unquote the system. And my heart, I have a real place in my heart for some of these fellows, because I've read a lot of these cases, and I'm going to talk to you now about one that really broke my heart, and it's here somewhere in these papers. But he was a locomotive engineer, and he was 34 years old. And this was such a sad case, such a sad, terrible case, that I went to his funeral. And he had come apart with his wife, and they're both in court. And they were both locomotive engineers. And he was coming apart. His personality was coming apart. And this, I don't think, was very apparent to the judge. But in any event, he knows he has to go. Doctors have told him he's got to go home and get some rest for a little while, because his despondency was so great. And again, the court doesn't pick up on that. So they charge him. He's on disability, and receiving $1,000 a month. And they charge him to pay the wife, now becoming, I think she was by then the ex, or nearly the ex-wife, $2,000, $1,000 for herself and $1,000 for the child. And nobody seemed to pick up on the fact that this fellow was, it was a terrible thing, that this fellow sinking. And he says, the master, whoever it is, the court once says, oh, well, it won't be long before he'll be up to work again, something like that. But the fellow disappears, and nobody knows where he is, and nobody seemed to, well, this is just too slim to say more. But one of his dear friends was worried and went where he used to live, wasn't there. And he just took a little walk into the woods and found the fellow hanging behind himself. And that case bothered me so much that I actually went out and went to that funeral myself. It was just such a huge tragedy. A young boy like that, 34 years old, and couldn't get help. And the interesting thing is that he had a daughter from a previous marriage, and that daughter was at that funeral. And it was a terrible tragedy to watch. And it's just unbelievable. How can something like that happen? But I guess it happens too many times.
Yeah.
Too many times. But it broke my heart, and I couldn't get through the funeral. So of course, when I was leaving, of course, the guys are coming up to camp, Senator Coles, and we wonder, go away. I looked around, I said, don't you understand? I don't see you crying like this. But that was a huge, sad, terrible thing, a young boy like that. And, but it hurt me deeply. It took me days to recover. Days and days to recover. And that daughter of his, she was so devoted to him. And he was from his first relationship, not that girl relationship. But I just remember I had to turn around and say to the cameras, please, fellas, give me a break. Please give me a break. This is really a sad time. And I can't tell you why that so bothered me, that case, but it was just a sad, terrible thing. And you know what? That is not uncommon. That is not uncommon. Years ago, when I was working on these files, everybody was organizing. You know, teenagers were organizing, grandparents were organizing. And I would get phone calls on Monday after the grandparents had their meetings on the weekend or whenever, and they would proceed to tell me, Mrs. So-and-so and her group's son committed suicide. And I kept always trying to get, so I could do some counting. Instinctively, I wanted to count it and record it, but I could never get that going for whatever reason it was. But you must understand that, you know, there was a lot of those colossal funerals and episodes and heartbreaking. And this one, I just don't know why somebody in the group didn't go and say, you're not well, I want to take you home and look after you for a day or two. And if that person could have found somebody to do that, the possibility existed, he might have lived.
Let's take one more quick
But he
question.
hanged himself. Can you imagine when his friend goes, walks in and finds him? That friend has to recover. Please, go ahead.
One more question over here.
Yes, I read that in 1995 you said that behind every abusing husband is an abusing mother. I only have two very quick questions. Did you say that, and could you expand on it?
Tell me more about it. Do you remember what
That's
day it
what I
was?
read. It was at a women's conference, I think, in 1995.
wasn't
Women's
really
Day, you
women's-
said,
Well,
behind every
it was on
abusing...
International Women's Day.
Yes.
I don't think it was a conference.
Okay.
But it was purely accidental. Totally unplanned, because I remember when I went home and I said to my husband, that gave me, but I said there's something that a couple of women took a great reaction to it. Well, I had support, a huge support. So I didn't give it any thought. I said, my husband, could you believe this happened? And this journalist came to talk to me. And, you know, they run after you. Well, my dears, next morning, I was away from my telephone, ringing. It's o'clock. Senator Gould, we want to interview with you right now. 6:10, can you make it? So I said, something's up here. So I got up, got out of bed. He said, give me a few minutes, sir. Got out of bed, got on the phone, and phoned my then royal secretary. I said, I don't know what's going on, because it was on 6 o'clock news. Then there was another interview at 6:30. Then I had another one at 7 o'clock. So I knew something big was happening. So I said, Candace, you go into my get in my office, and I'm going to take every phone call. I'm not going to duck any. I'm not going to pretend that I wanted. And I did phone calls all day from all over the country. So this journalist in Vancouver, and then there was this one in Edmonton, and then that one in Calgary. Huge. It was huge. And it went on for days. And it was International Women's Day. And what I had said, we have to look more carefully, something to that. We have to look more carefully at what's happening in those children's lives. Because behind every single one, there is a, I know that these words were not even thought of or planned, but they sure were quoted. And I had front page coverage in every newspaper in Canada. Every single newspaper in Canada, province by province, every single one. But the dialogue was very interesting. There were people very on phoning me and saying to me, Senator Coles, you know, I'm listening to this result. He says, how come it is that we haven't noticed this before? Because I was standing in a supermarket or waiting for a bus or something, and all of a sudden you see a child wiggling, and then before you know it, he's screaming and he's crying. And you just think, what is the problem with the child? And you comfort it, but instead you have a whole slap or something. I've seen that, a whole slap goes right across the child's head. So you learn to understand that these things are always happening. But I've always believed, and since then I really believe there's some ground for what I said, that because that child grows up to be the man the child was ever going to be. And it's a little sad for anybody else to misunderstand a child like that. And I don't think that too many people would stand by now and watch something like that happening at it and stop and not say something.
Really sorry to cut in,
Go
but
ahead.
we're just
We're
running a
good.
little bit short on time.
We're good.
Senator Coles is here today and tomorrow. Is that?
I think I am.
Okay, excellent.